On the 9th of February 2025, there were two fairly significant announcements to the right to manage process. Firstly, leaseholders will no longer be on the hook for landlords' reasonable legal costs when bringing a right to manage claim, which was often a problem because not only does it cost several £1,000s, but this was usually a figure that wouldn't be known until near the end of the process. And as with many processes in leasehold, sometimes the costs could be reasonable, in other cases they could be very unreasonable, and it just created another hurdle, another reason for claims not to proceed, and it did perhaps prevent some claims from being brought. The second significant change is that the threshold for how much commercial property can be within a building has increased. So at the moment, the way the law currently stands, if there is more than 25% commercial premises, so something like a ground floor shop, which is more than 25%, that can exclude the building from an RTN claim. And the same rule applies at the moment for collective enfranchisement. So it really does put leaseholders in a bind if you've got a ground floor shop, which perhaps has got quite a big footprint compared to the flats, and it just takes them over that 25% threshold. The great news is the threshold's moving up. It's going to be 50%, which should pull lots more buildings within the regime of right to manage. There's no word yet on whether this change will be made to collective enfranchisements this year, but I remain cautiously optimistic that that is something that will happen.